Okay. Well, thank you very much for those joining us. I think we're just gone past the 200 mark, which I think is fairly indicative of the, I don't know if excitement is the right word, but certainly interest that there's been in the Renters Reform Bill, which, as you'll hear, has been long awaited. Whether that wait is worth it, whether it's justified in terms of its impact, obviously we have, to a certain degree, got a lot of time to wait and see. And there's a lot of regulations that will inform part of the process as well. Before passing to Jack to open this, as I say, can I welcome you all to this webinar and just alert you to the fact that Cornerstone Barristers have got a housing day, that's its annual housing day, coming up on the 9th of October 2023, which will be at the Royal College of Surgeons on Lincoln's Inn Fields. And also the public law team, of which both Jack and I are members, have a public law week of webinars starting next week with challenging policies in the administrative court. And there's a webinar a week, including a live session on Thursday. So you can find all that on our website. And if there's any questions people have on it, then I'm sure Jack and I are happy to answer that by email as we complete this webinar. But going back to the bill, we're going to be starting off by having a look at its proper context and how we got where we've got to. So first of all, over to you, Jack.
Yes, so I'm going to talk a bit about the context. I'm not going to spend too long on this, but as many of you will know, the housing acts which govern most assured tenancies in this country are the Principal Housing Acts, in particular the Housing Act 1988. It's been quite a long time that there's been such widespread reform as is proposed under the new bill. A couple of points to note. Obviously, Wales has started to do its own thing completely with the Renting Homes Wales Act 2016. So one of the things to note in a broader context at this point is that England and Wales are effectively doing their own thing in terms of housing law now, and this bill restates that really. In terms of the development of this bill as a policy idea, Theresa May, when she was Prime Minister back in 2017, proposed a once-in-a-generation overhaul of housing laws. Now, there's been several prime ministers since then, and several further pledges, including in the Conservative Party's most recent manifesto in 2019 in the general election. But that culminated in a white paper which was produced last year, and then this bill was presented to Parliament earlier this month. Now, the objective of the bill is to ensure that private renters have access to secure and decent homes, and that landlords can retain the confidence to repossess properties when they have a good reason to do so. We're going to spend a little bit of time today looking through some of the details of the bill as it's been presented to Parliament. But one of the important things to note right at the outset is that this bill is very much in its infancy as it goes through Parliament, and will be subject to further amendments, additions, potential omissions as well, and also a lot of further regulation is expected in relation to this piece of primary legislation. So whilst there is the starting gun has been fired, the race is very much not over at this stage.
Okay, and before I just start on this next piece, can I just make it clear that the webinar itself and indeed the PowerPoint will be available hopefully tomorrow, if not the day after, and you can always go to our YouTube channel or to the website to find those. So they will be provided. And I also hope the person who couldn't hear us can now hear us. In terms of early changes and matters to come, I indicated earlier that there was a lot of the detail which is still to be thrashed out. A lot of it is done by regulation, and in that sense, sometimes we've only got the broad outline of what is being proposed. We do know that in respect of student accommodation, there has already been indications from government that some of the changes in respect of fixed-term tenancies and the ending of fixed-term tenancies and periodic tenancies being the norm on an assured, non-shorthold basis are being looked at in respect of student lets. And you can see two articles there from the NRLA and Property Mark on those issues. And it's just an example of the kind of things which should be looked at as the matter both goes through Parliament and continues its lobbying, as it were, because there's still a lot of industry interest. But in terms of what's to come, I think, as Jack will indicate, a lot of the interest in this bill was obviously focused on the abolition of Section 21 and the abolition of assured shorthold tenancies. And a lot of the interest in the bill, of course, if we look at the next slide, was in relation to the fact that it applies to the private rented sector, and that's how it's very much promoted. And if one looks at any of even the government press releases, that's how it's promoted. But of course, it impacts in part and at times, and to a great extent, on the social sector, the social housing sector as well. And we'll deal with that as we go through. But in particular, there are certain things which are yet to be seen. For example, decent home standards being applied to the private renter sector. These are just, in a sense, bullet points, because either they'll come up in terms of separate legislation, or they'll be made part of this legislation, or they are still to be debated and to be considered. There is questions of bans on people not wanting to let to people on benefits or people with children. And some of you will have seen some successful actions. I hope I haven't got the chambers wrong. I think it was Garden Court did a couple of very good actions with shelter on that last year, which were very successful and quite properly successful in fighting that. Strengthening local councils' enforcement powers and introducing a new requirement on councils to report on enforcement activity, again, is seen as something that is probably going to be necessary. And of course, a lot of concern about what the bill is doing, and when we look at the detail, it's all very well having a wish list, for example, as to things like financial penalties, as to what landlords should be doing. But is there the resource there to actually enforce it? And therefore, there's going to be a lot of question as to resources, as well as any additional enforcement powers that may or may not be necessary at a local level. Those of you who are experienced in the court may look with some skepticism at the modern digital court service and the prioritisation of ASB cases. Yes, we've had 3 years of remote hearings. We're getting better. But I think one of the private landlords' concerns was always the speed of the court process, because obviously they'd been used to the Section 21 model. I'm not suggesting that that's particularly quick, but obviously if it was undefended, it wasn't particularly difficult. And obviously they were concerned that if they're no longer able to use that process and they were having to go to court and look at things like antisocial behaviour or rent grounds, whether mandatory or discretionary, was it really geared up to the landlord model in the private sector? My view has always been is that, well, it is. There's nothing special about private landlords that justifies any prioritization of their cases over, for example, social landlords. But I think the court service suffers and has suffered for many years from a severe lack of resources. And we've all experienced that, a lack of judges and a lack of staff, which means that it's not the service which it should be. So if there's any commitment to produce a modern digital court service, it requires money and it requires people. And I think, therefore, the devil is in the detail on that. So a perfectly good, laudable ambition, but the white paper is just that, and it needs to really be seen at the end of the day with solid results and solid conclusions. And end-to-end digitization of the court process is a case in point. And there was also a question about lifetime deposits. And as you can see there, the Conservative Party actually went as far as making it a manifesto pledge to make it easier for private tenants to move around the sector, as it were, and not to have to try and get the funds from one landlord and then pass it on to the next landlord, and there being an inevitable overlap, etc. And are we going to be seeing anything of that type in either this legislation or similar legislation that may come up? So I think when we look, and as we go through this afternoon's webinar, we'll see certain things which are fairly obviously going to happen and fairly obviously going to have an impact, and certain things which it's fair to say are only part of a much broader process and will require much more detail and maybe much more legislation to know whether it's actually going to achieve its objective. But if I leave my part there and look to Jack to deal with the question of the headlines of what the Act actually, or the bill, I should say, actually proposes to do.
Yes. So in very brief terms, when the bill came out earlier this month, Andy and I put together a quick note which summarised its core contents. That's available on Chamber's website and provides actually some of the links to the relevant pieces of guidance and the explanatory notes which accompanied the bill when it was published. But in headline terms, the bill is structured, it's in five sections. Those 5 sections are address tenancy reform, residential landlords, enforcement and enforcement authorities, supported accommodation and temporary accommodation, and then there's a 5th general provisions part. There's then 4 schedules as well, which include things like some of the grounds for possession amendments and also procedure in relation to some of the enforcement powers which have been introduced. And then there's quite a few explanatory notes that accompany the bill. Andy and I have both had to look at these, and they are fairly helpful in terms of explaining what's being done for the most part. But one of the things that the bill and that we don't have to date is the regulations which are referred to throughout the bill in different contexts. And we do expect that there will eventually be quite extensive regulation as well, accompanying some of the measures which are set out. Andy mentioned earlier that 2 of the headlines measures which got a lot of media attention at the time were in relation to the changes to tenancies and to Section 21, and that's understandable because they're fairly fundamental. Taking the changes to tenancies first, so under the 1988 Act, you obviously either have a fixed term tenancy or a periodic tenancy in its nature. What the bill is proposing to do is to have a simpler structure where all assured tenancies are periodic. And so it seeks to abolish fixed term tenancies and it seeks to abolish assured shorthold tenancies. Obviously here we're concerned with tenancies under the 1988 Act, so that's not going to affect secure tenancies or Rent Act tenancies. And the thinking behind this measure is effectively to say, we want to give tenants more flexibility to end the tenancies when they need to, for example, when there's an issue with condition in the property or something like that. And the proposal effectively would to have periodic assured tenancies. The period would not be in excess of a month, and existing rent periods for tenancies which are for periods of greater than 28 days would be, the rent period would be recalculated by a formula which is set out in the bill. Now, the second major change is in relation to Section 21, and obviously that's associated with the changes to tenancies, because what Clause 2 of the bill proposes to do is to omit Section 6A and Chapter 2 of Part 1 of the Housing Act 1988. Now that sounds nice and technical, but effectively what that means is it's planning to get rid of the demotion to assured shorthold tenancies because of antisocial behaviour, and it's also proposing to get rid of Section 21 and the provisions relating to assured shorthold tenancies. In practice, what that means is that the possession proceedings would be through the normal Section 8 notice instead, and the revised grounds, rather than via the Section 21 notice. And the government in the explanatory notes acknowledges that there's going to be a very large number of consequential provisions which are required in relation to the abolition and the omission of assured shorthold tenancies. Now, some of these are provided and referred to in the bill, but it's anticipated that there are further consequential provisions which are going to be thrashed out in the coming weeks and months. So Andy's now going to get onto the meat of the bill and start talking about the changes to possession grounds.
I am, and I'm going to start off with a lovely chart I've managed to prepare. Whether it's as nice as the one on the explanatory part of the Act, which if I hold up, right at the back of the explanatory notes, you'll see a very nice table which sets out each of the grounds of possession, whether they're mandatory or discretionary, a summary of what those grounds are, and the notice period that you must give. And in short form, this slide and the one 2 away from it will explain both the grounds, whether they've been amended, whether they're just new grounds, whether they've been repealed, and the notice periods. What I don't propose to do, particularly in a short webinar of 45 minutes, is just go through each of those, which I'm sure you're all glad to hear. But I just want to really just highlight a couple of issues to do with the grounds and what's being done. And just to give you an idea well, if you're not going to have Section 21, if it's not going to be that easy to get possession of a property that you own and let out, what is there in its place for landlords? And for example, you can look at what they've done in terms of some amended grounds. I mean, ground 1, for example, is a ground which deals with the question of the need to occupy the property with the landlord or their family. It's always been there. It's a mandatory ground, but a court is also required to do that. But they were meant to have told previously whether they were going to be doing it on the particular tenancy. In other words, you'd have known in advance, yes, I'm going to let this property to you, but I may need to have it back because my family or myself may need to move back in. That's gone. So it's much more easy to use the fact that I need to occupy it with myself or my family in future. Under the previous ground, landlords were also required, as I say, to provide that notice, and it's much easier. So that's an example of where they've tried to make it easier. Now, one of the questions we had before this webinar started was about landlords getting round, private landlords that is, getting round this process. And of course, the difficulty with that is, and this is a good example of that, is it's a question of fact, isn't it? Because it still has to be litigated. And if somebody doesn't accept that, in fact, that the landlord is actually being honest in what they're saying and why they need the property, and that it's needed for their self or their close family or spouse or whatever, then obviously that's a matter of challenge and that's a matter of fact, and that obviously could get eventually to trial. So it wouldn't necessarily be a quick ground for a landlord, and it is one that has court oversight. So of course there's understandable and natural concern as to how that operates, but it is, as I say, not something that the court is totally powerless on, and it can make adjudication on. The difficulty, of course, has to be accepted that not all people challenge cases. Not all tenants are in a position to challenge or do challenge, and I do recognise that. But if they do, it is a matter for, of course, the landlord to prove their case in court and prove that ground 1 is satisfied, and that they've given the 2-month notice required for that particular ground. One of the things that is odd, just if we go completely the opposite end of the grounds, is ground 14, which for those of you who do a lot of particularly social landlord work would know that it's a fairly common ground for landlords to use for antisocial behaviour. And it may be that private landlords are going to have to get into the social antisocial behaviour field as well. And of course, it's probably going to be a ground 12, breach of tenancy, which isn't touched by this reform. But ground 14 has slightly changed, because it now says, if we go back, we now says it's capable of rather than likely to cause ASB. Now, I've seen, particularly on my normal kind of source of knowledge, which is Twitter, a lot of interest about that and about, oh my God, that's really kind of dramatic, and why have they done that, and so on. I have to say I'm less concerned about it, because it's the kind of language that you would get, for example, on an antisocial behaviour injunction under the Antisocial Behaviour Crime and Policing Act of 2014. And in reality, I don't think it broadens it to any massive extent or significant extent. I'm not saying it's totally irrelevant, and I'm not saying it's totally without concern, but I don't think it has the worry that sometimes is given to it. I think of more interest is 8A. And 8A is a mandatory ground which is looking at rent arrears. Now, remember, we're talking here not about local authority landlords who can only really rely on grounds 1 for rent arrears. Remember, private landlords and social landlords can rely on 8, 10 or 11, 8 being the mandatory ground of 2 months or 8 weeks arrears, 10 and 11 being either persistent delay for 11 or arrears at various points for 10. They've introduced 8A, or they propose to introduce 8A, and 8A is a ground that says you're going to be in arrears for 8 weeks or 2 months, depending upon your cycle. And you're in arrears of that amount within the last 3 years on 3 occasions, 3 separate occasions. And the way you divide those occasions is that if you dip below 2 months or 8 weeks, whichever it is, that's the end of one occasion. And if you then go back up above the 8 weeks or 2 months, that's the second occasion. And if that happens 3 times, then it is becoming a mandatory ground. Now, I think that is probably a concern, and also seems to ignore, as I say, although it's a discretionary ground, ground 11, which is about persistent delay in paying arrears. But certainly those commentators I've seen expressing concern on 8A, I think I very much share that concern. And I think there is, probably some lobbying to be done. And I wonder to some extent as to what the purpose really is and whether it's going to produce the benefit to a private landlord that they said it is. I'm not so sure it could, and it will provide that problem. And so those are the kind of matters that I think are of concern. You can see that there are particular issues to do with supported housing in there, and there are particular issues to do with people who are using their accommodation for those who are homeless and being able to get out people from their property because that's the use they wish to put it to. And of course, there are amended grounds on things which already exist, such as death of a tenant, where there's an extended period of time which people are given now 2 years to make a claim for possession on such matters. So there is a whole raft of changes, both amended, new grounds, and I say repeal grounds is just holiday accommodation, which is probably not the most interesting point of this talk. But if you look at the next slide, you can also see, as you might imagine, that there are going to be changes in terms of notice periods and so on. One of the good changes is what you see at point 3, and that's that if universal housing costs are unpaid and there's entitlement to it, that rent element is ignored. Now, to some extent, I think it was, from recollection, is it North British Credit and Matthews, I think, which was determining that if you actually had a definite payment from housing benefit, as it then was, then that could be treated towards an actual payment, treated as an actual payment and reduce the arrears. And if that took you below 8 weeks or 2 months, all well and good. It's along those lines, and obviously quite properly, that somebody shouldn't be penalised because they happen to be waiting for an amount of housing costs they're entitled to. And because, of course, we're talking about assured tenancy, we're talking about the DWP and not the housing benefit element that one would get for local authority tenants through housing benefit. So that's probably quite a positive matter that's worth, lauding the government and saying that that's appropriate to do so. As I say, there are a whole raft of changes in terms of notice. If we have a look at the next slide, you can see that you can issue a ground 7A case. And for those of you who don't do a lot of this, remember ground 7A is the mandatory, or the absolute ground, I should say, for possession on various things such as a serious offence or closure order or such like. And you can issue that immediately after you serve the notice. Now, I've put in brackets there that it's 28 days at present. And one of the reasons for that, is that although it's not statutory, local authorities with their mandatory ground requirements, which are the same effectively, have to have a statutory review after the notice has been served and if it's been requested within the 7 days. And although local authorities, housing associations haven't had to, they've generally followed that process. Why there isn't provision to allow for a review process is beyond me, to be quite frank. But all I would say is that if you're a good housing association, you would probably, even if you could issue immediately after the notice, I suspect your present antisocial behaviour policy, for example, would require you to review any request in line with what happens under the 1985 Act. And I suspect, therefore, that you won't be issuing immediately. But if you want to, you can. And certainly, as I say, private landlords can, although I suspect it's not going to be a ground very much used by private landlords anyway. And again, without just reading out what you see in front of you, you can see there are different and changes to various notice periods, longer periods of notice for certain things such as rent grounds and certain other grounds that you've seen on the previous slide. I just made mention of the fact that a tenant's notice to quit is extended to 2 months, sorry. So you can't just give a 28-day notice unless you agree something in writing with the landlord. Bizarrely, there is maybe I've misread this, but under clause 3, I mean, maybe Jack's got a better reading of it than I have, but under clause 3, you can't get a possession order under ground 7A or 14 made out to take place before 14 days of elapsed from service of the notice. Well, believe me, if you're in court within 14 days of service of the notice, tell me which court it is. It's certainly none that I go to. But maybe there are courts that are that efficient. Yes, they give you at least 14 days from the date of notice to whenever you have to leave under the possession order for ground 7A and 14. So I'll leave that there, but I really would commend you to have a look at the explanatory notes, which set out very well each ground of possession, why it's been amended, why it's been added, why it's been repealed, and really goes through the detail of that, and is a very helpful document, although it's not of any legislative effect. Jack.
Yeah, so I'm going to spend a little bit of time talking about two aspects of part 2 of the bill. And these relate effectively to the financial penalties and enforcement issues that I'm going to go on to discuss shortly. But these two are the landlord redress scheme, which has also been referred to as the Ombudsman elsewhere, and the PRS, the private rented sector database. Now, it's worth noting that the database had actually been a policy proposal that Labour had also been campaigning for. And so it seems like the parties are broadly aligned on seeking to get this into place. We'll discuss a little bit about the politics at the end of the presentation, but these are two aspects which I would imagine will come into force in some way, despite the parliamentary process. The first aspect is the landlord redress scheme. Now, it's chapter 2 of part 2 of the bill, which sets out provisions for this. Now, really, what the scheme is proposed to be is effectively a scheme for independent investigation and determination of complaints by prospective, current, or former tenants of residential landlords or their representatives. So it's a fairly broad scheme seeking to encompass a wide range of people who might have complaints about residential properties at any given point in time. It's worth noting at the outset that there's a lot of provision further and subsequent regulation. So the details aren't especially clear as to how this is going to operate in minute terms. However, it's clear from the bill that the decision, a decision under the scheme would be made enforceable as if it were a court order. So it'd be there would be some teeth to it. But that would be subject to the Secretary of State exercising its discretion to make provision for it to be enforceable by court order, like a court order, by further regulation. So that's got to be fleshed out as well. It's anticipated that landlords will have to join this scheme, but the details as to when and whether they all are required to be members at the same time is going to be subject to further consultation, I think. The explanatory notes talk about whether a staggered approach would enable a phased rollout more effectively. And so it seems like that's still up for debate about exactly when this is going to come into force and who it's going to affect straight away. But it's also worth noting that that within the scheme, it's envisaged that there'd be also a mediation scheme within the scheme. So you've got a bit of a Russian doll effect there. But that mediation scheme is effectively to try and work on mutual resolutions. So where a landlord, for example, has a complaint with a tenant, there'd be a mechanism for resolving dispute through that. So with the landlord redress scheme, I think the headline is lots of detail to be fleshed out, but ultimately it's seeking to provide a more costly and more efficient way of resolving disputes, particularly from the tenant side. In terms of the second measure, which is the private rental sector database, this has also been referred to elsewhere as the property portal. I think it was referred to in the white paper as the property portal. This is in chapter 3 of part 2, so this follows on from the redress scheme. But really what this is doing is trying to create a database of entries for existing residential landlords and prospective residential landlords, and dwellings which are or are intended to be let under residential tenancy. Now, it's envisaged, I think, that this would be compulsory for all landlords, subject to further regulation. And it looks like that the entries might actually be publicly available. So there's some provision in the act, in the bill rather, that sets out a requirement for dwellings and the associated private landlords to be registered on the database before they can be let, or before they are advertised or marketed to be let. And I think one of the things that's driving this property portal is it's firstly trying to professionalise the landlord sector. So it's trying to say you need to have your ducks in a row before you start letting out property. And obviously for big providers that's going to be relatively straightforward, but it is going to be an additional regulatory burden. But then there's also something on local housing authorities as well. So there's a duty that's envisaged within the bill for local housing authorities to make entries onto the database for a person receiving a relevant banning order or being convicted of a banning order or receiving a penalty from a local authority in relation to a relevant banning order. So there's also an enforcement aspect to the bill. But I think effectively what the property portal is trying to do is to try and promote professionalism and also trying to promote transparency for consumers or for tenants, that is. And so having discussed those two aspects, I think that leads on quite clearly to the financial penalties and the enforcement aspects of the bill. There's several different things that are envisaged within the bill in terms of duties on landlords and on housing associations as well in relation to enforcement. There's amendments to there's insertions of new provisions in the Housing Act 1988, which effectively try and prevent things like reletting or marketing of a dwelling house for a period of time, beginning with date specified when the landlord has got possession of a property on ground 1 or ground 1A in Schedule 2. Effectively, what this is trying to do is to try and stop people from skirting around the edges of the grounds for possession and seeking to relet and trying to basically avoid the Section 21 process that has been removed. There's also provisions in relation to civil penalties that local authorities can impose in relation to unlawful eviction or harassment of occupiers. So this is effectively an amendment of the Protection from Eviction Act 1977. And what that's really trying to do is to try and provide alternatives, flexible alternatives. It doesn't have to just be a prosecution for the offence, but you can also seek to issue a civil penalty, i.e. a fine. There's specific offences and civil penalties introduced in relation to the breach of regulations arising from the two schemes and database that I've just set out. I'm not going to go into the details of those, but effectively what that envisages is fines for breaches of regulations, further fines or potential prosecutions in relation to continued breaches of those regulations in each case. There's provision for further regulation about that, so there's still aspects of the scheme which need to be fleshed out. But I draw your attention to Schedule 3 of the bill, which sets out provision for the procedure, appeals, and the proceeds of financial penalties in relation to those two aspects. It appears that appeals would go to the first-tier tribunal by way of a rehearing. And just note that proceeds of the financial penalties that could be raised under those two separate parts of the bill could go towards meeting the costs or expenses incurred with associated with the bringing of those offences or penalties. But any proceeds that weren't so applied would have to go to the Secretary of State. So there's limits on how much that would benefit local authorities. Finally, there's further provision for enforcement authorities. As Andy's mentioned earlier, how much teeth that has in terms of the duties. There's imposition of duties, including a duty to enforce the landlord legislation in the area. Whether that comes with resource is not clear. Obviously, that's going to be a matter for politics, really. But there's provision in the bill for the local housing authority to take enforcement action in respect of the breach of landlord legislation outside its area. So this is slightly different. But I think I'll leave it there for financial penalties and enforcement. That's a quick overview, but effectively lots of details still to be fleshed out.
Thank you very much, Jack. Before I start on shared ownership, can I just say very quickly about resources that it is largely a political question, of course, but that's not to say it can't be a legal question as well, particularly if, for example, the local authority finds itself challenged for not doing something, and its effective defence is that we haven't got the resources to do so. I suppose it's not dissimilar to the Imam and Croydon, El Kundi and Birmingham type. You know, we don't have the properties to satisfy the 193 full housing duty, but it can still be a legal issue. But moving on to shared ownership, if you go on to the next slide, Jack. One of my favourite topics, shared ownership, he says, joking. Shared ownership, you might think, of course, is, well, of course that's going to go because you don't have fixed term tenancies anymore, and that's good, isn't it? And of course, I would say, yes, I hate fixed term tenancies and flexible tenancies. Of course, it's good that it goes. But there's a more fundamental future for shared ownership, which we'll come to. Just to say at the moment, what are shared ownerships? Well, of course, they're primarily housing associations being the landlords, although there are particularly some older ones, which are local authority landlords, but they're primarily housing associations as the landlords giving out the 90 years or 99-year tenancy agreements, and the person remains at the moment to be an assured shorthold tenant, and therefore subject, so long as they live at the property as their only or principal home, to the normal Housing Act 88 regime, and that includes the possession regime, which includes, for example, Ground 8, which is often confused sometimes the county courts. And you can see there has been attempts to vary that, the most obvious one being the Richardson and Midland Hart case. And therefore, forfeiture traditionally has only been required if the assured tenancy status is lost. Whilst tenancy status is retained and the person is an assured tenant, Section 45 in the Richardson makes it quite clear that you have to go down the 88 Act route as if you were a periodic or a 5-year fixed-term tenancy. Makes little difference that the fact that yours happens to be 90 years. You're not one of the excluded agreements from an assured status seen in Schedule 1 of the 88 Act. And so we do have those issues. And of course, there are questions about the fact that shared ownerships are long leases for first-tier tribunal purposes. And so you need to have a determination of a breach if you're going to go down the forfeiture route because the tenant no longer lives at the property as their only or principal home. But as I say, so long as they've moved back, and remember, you don't lose your status permanently as a shared owner if you're subletting, for example, that you would do as a periodic tenant. It means that as long as you move back, you are subject to the 88 Act regime. So that's the current position. It may seem harsh, but that's the current position. If we have a look at what's being planned for shared ownership, it's perhaps unsurprising. If we have a look at the next slide, Jack. There's a new paragraph to Schedule 1. And as I say, Schedule 1 is the paragraph that excludes agreements, certain types of agreements from being assured tenancies. And this will encompass any fixed term tenancies of more than 7 years from the date of tenancy, which of course is going to be all, let's be blunt about it, all shared ownerships. There are still going to be certain transitional provisions in terms of existing cases, and you can see that on the third bullet point there. But save for that, assuming the Act is passed in its present form, in your shared ownership stock, and I'm talking now to those, either those representing shared owners or those representing the housing associations, you're going to have to go down the forfeiture route. And you're going to have to go down the declaration unless an admission is made as to the breach of whatever that breach is. And of course, one of the issues that brings very much to the fore is waiver. And that's the one that's always concerned me, because let's be blunt about it, the vast majority of shared ownership situations, landlords have continued to accept rent, whatever the breach, antisocial behaviour, rent, subletting, whatever it is, such that if they had been a forfeiture case, they'd have been seen as waiving the breach. And therefore, that's going to lead to a very serious change in practice. And for those people operating shared ownership schemes, they're going to have to be very careful as to how they treat matters where there is an alleged breach of tenancy, whether that's rent or whether that's some other breach such as subletting or damage to the property or whatever it is, antisocial behaviour or whatever. I've only mentioned the last bullet point just because it's very recent. I think it was yesterday, actually. There was the Court of Appeal case about the right to manage, although it probably maybe goes over to enfranchisement or lease extension, question mark, and about the fact that even shared ownership where you haven't staircased to 100% are able to enjoy those benefits. And of course, that will have an impact on housing associations as well. But it seems to me, therefore, that the future for shared owners is very interesting, shall we say. I think for the shared owners themselves, they would obviously have some protection from no longer being subject to, for example, potential Ground 8 proceedings, despite the fact that they may have obviously invested significant sums into their property. And for the landlords, of course, they've got to be very much alive to the fact that they've got a very different model than what they anticipated at the start. And not only because of the recent cases, as I say, of waiving ground rents and whether that impacts upon the wider stock that they may have when it comes to right to manage enfranchisement or lease extensions, but just from the very basic possession side of things, they can no longer treat, or they'll no longer be able to treat shared owners as simple cases of Housing Act 88 cases under which Schedule 2 and the grounds of possession to be found there apply with a notice seeking possession. So a much more complicated case will apply. And it may mean that you get more injunctions. It may mean you get, as I say, different practices as to how people are geared up to dealing with such matters. To a certain extent, it's a wait and see, but it's a very clear change and a very, in a sense, it seems to me, a clear impact. Over to you, Jack.
I think it's you next.
Oh, it's over to me. Yeah, this is like a well-oiled machine, isn't it, really? Over to transitional provisions. Yes, Schedule 4 sets out the transitional provisions. They're not a great many of them in many ways. But just to give an example and a flavour of them, the idea is that if you've got a fixed term tenancy now, for example, those would continue until the expiry, and of course they wouldn't be able to continue after that. If you happen to have a Section 21, an assured shorthold tenancy, periodic tenancy, that would convert after the Act into an assured tenancy. Save if you have issued a Section 21 notice within the extended period. We don't know when that will precisely be. That's a matter of regulation. But if you have served that and it's still within time, so it's still within the 4 months to do something with, or you've even gone further and you've issued proceedings based on a Section 21 notice, then it will still be treated as a Section 20, as a short shorthold tenancy, and you'll still be able to proceed with the Section 21 claim. So in terms of, therefore, tenancies, wait to see the end of the fixed terms, changing to assured and unshort hold tenancies, unless there's a Section 21 process which is still alive. Rent increases, which we haven't dealt with, but just simply to say that in terms of the changes to rent increases, the way I would put it is this: for private landlords, they will have to go through a Section 13 process. They won't have any choice but to do that, and they'll have to give a 2-month notice, not what is traditionally for most agreements a 28-day or a 1-month notice. They'll have to give a 2-month notice, and the parties will only ever be able to agree a lower figure in the Section 13 notice that the landlord serves. And therefore, if the landlord wants to stick to the amount that they want, or indeed even want more, then they're going to have to go to the tribunal. Now that's the only valid way to increase, or will be the only valid way to increase notice. For what they call low cost agreements, which is most of the private registered provider sector, although there's some exceptions to that, so not shared ownership, not some specialist supported housing, not some student accommodation, etc. But for most low-cost accommodation, they don't have to go down that route. They can still give the 1 month's notice. They can still have a term in the tenancy which provides for the rent increase. But certainly, however you've done it prior to the Act coming into force, if that ever happens, and Jack will come on to that shortly, pre-Act rent increases will be respected and legitimate. Similarly, as you might expect, what I say, this extended application date, and that's a regulation date that we're waiting to see what it will be, but it'll be some date, obviously, after the Act is brought into force. That will not attract the financial penalties or criminal offences for the matters that Jack raised in his part of the talk earlier. And similarly, issues like, for example, just to give the two issues you see at the bottom, the fact that you're going to have to give written tenancy agreements in future, of course, never a problem for the private registered provider sector, but is a problem for some landlords, and some arrangements which perhaps are very informal, but actually, technically speaking, are at the moment short-hold tenancies. They're going to have written agreements, and there's going to be a transitional provision which allows for a mere advice for existing tenants to be advised of changes brought in by the Act, but certainly going to require, even at that stage and at that level, some action by the landlord. And lastly, the pre-Act notices to quit, that's the tenant notice to quit, which at the moment can be 28 days or 1 month, which in future will be 2 months, will be valid if otherwise valid. And then they will be treated as valid even if they haven't yet ended and had effect. As long as it's been served prior to the Act coming in, that should be sufficient. The problem with transitional provisions is that there's a lot of things to be worked out. I mean, for example, you've still got issues to do with homelessness to be worked out. Somebody asked us a question before we started, which was sent through to us here in Chambers, and they said, how's it going to affect homelessness? Well, we know, for example, that section 175, which defines homelessness, and one of the definitions is talking about if you've got a section 21 notice and you've got less than, I think it's 56 days, then you are treated as threatened with homelessness. Well, obviously that won't apply because there will be no section 21 notice. And there's other provisions which of course refer to short-hold tenancies, which again are going to be removed from Part 7 of the Housing Act 1996. So there are going to be changes, and there will be some impact on the relief duty in particular. Again, the types of tenancies you may offer in satisfaction of those duties. But in broad terms, because there's only going to be one private rented offer of tenancies, it's going to be the assured tenancy, and that therefore it should be fairly straightforward. So Jack, over to you for the final part, I think.
Yes. So what next? So as Andy's already mentioned, I'm not going to go into it in any more detail. There's obviously the potential for further lobbying in the political context. There doesn't seem to have been a huge amount of backbench rebellion so far from the Conservative backbenches. And it seems that the Labour Party in opposition are broadly on board with the bill, albeit fairly critical of how long it's taken to get Section 21 abolished. But that said, there is a ticking clock in terms of the timeline for this bill to be passed in this Parliament, given that there's a general election expected next year. In terms of the parliamentary process, the path to royal assent is only beginning, as I mentioned earlier. So we've had the first reading, which is just the formal presentation of the bill, where there's no real debate. MPs will next consider the bill at the second reading, where they'll have a debate about the general principles. Now, there's no time that's been set for this debate, as far as I'm aware, to date. The bill will then go on to committee stage and then to report stage before the House deciding whether it's going to agree the bill or not at the third reading. And then it will go to the Lords, and the House of Lords will consider it further amendment and then pass it back to the Commons. And so we've got quite a long way to go before the bill becomes law when it is granted royal assent. And obviously, like I mentioned earlier, there's potential for further changes, for further amendment, for further omission of material, and for further lobbying in the meantime. And so So whilst we've sought to provide an introduction to the bill today and an overview of some of the key provisions, once these provisions become law, it's very well that things might have changed. And so that's an important caveat to couch everything we've told you today.
Thank you very much, Jack. Can I just say, and we're now in a sense in the position of answering some questions. I've given a couple of quotes, one from the white paper and one from Michael Gove MP, which you may have seen and are just there as way of background. I also ought to say that we haven't said anything about pets. Now that may be because neither of us, I don't think we have any pets, do we, Jack? I don't know, but neither of us have any pets. So we're just out of our comfort zone. But somebody did ask a very good question, because obviously what's going to be coming in is that there's going to be, you know, not so much a right to keep pets, but certainly a landlord can only refuse, a private landlord, that is, can only refuse with good reason. But they are entitled to expect you to have insurance for little Tabby or whatever they call cats, or whatever the pet is, unless it's an ornamental pet. Jack and I have had, I was going to say many hours, but that's pushing it a bit. We've had many seconds of debate over what an ornamental pet is. I think we have probably goldfish, cockatoos, and there are other pieces, it should be said more seriously, of legislation, including from earlier last century, which also refers to ornamental pets, which are excluded from this. But generally speaking, in the private sector, the idea is that you should be able to keep pets unless the landlord has a good reason for saying no and has to put that in writing. If you do keep a pet, the landlord's entitled in writing to expect you to have insurance, and if you don't, it's an implied term of the agreement, and therefore you're breaching your tenancy agreement if you don't, and that then becomes a ground 12 potential case. Why that doesn't apply to the social sector, somebody cleverer than me, no doubt, has the answer in the question and answer sessions. I don't know. It may be because there's, in a sense, less of an issue in the social sector, although I'd be surprised if that's the answer. But certainly, you know, I suppose you could, in theory, have it, but it may be seen under the Consumer Rights Act, for example, as being an unreasonable term if you said you couldn't have pets. It depends where you are, of course, and what type of accommodation you're in, and it depends on what the pet is. But of course, whatever you're doing, of course, if it causes a nuisance, it's caught by the bog standard nuisance clause. So there are those kind of provisions which are there in the Act. But looking through the questions, I would say that, are there likely to be any changes to the requirements for a notice to quit? I don't see that there will be. I mean, there's a change to the tenant's notice to quit, as I indicated earlier, that they will have to give 2 months unless they and the landlord agree in writing otherwise. But in terms of changing it the other way round, I don't see that it could be. And remember, particularly for notices to quit, you're only going to have a notice to quit. Well, you're only going to really have a notice to quit if, you know, from a landlord's point of view, if the tenant's not living there. Otherwise, if you want the tenant out, you'll have to find a ground for possession, because these are going to be periodic tenancies, and therefore they will be renewed automatically each week or each month, or each 4 weeks, or whatever the period is. So I don't anticipate notices to quit being an area where there's going to be much change. And in terms of the only other one I would deal with before passing to Jack is that failing to provide a written tenancy agreement, most of these matters are going to be matters for the local authority, as I understand it. Whether the local authority itself, you know, is able to do that, whether they, you know, choose to do that is I wouldn't say it's a matter for the local authority, but clearly they have to consider what are their priorities. And of course, there is an overlap in some areas with licensing schemes. And no doubt in terms of the condition of licensing, there'll increasingly be maybe certain references, if it gets through Parliament, to the Renters Reform Act and some of its requirements and some of its positive requirements in terms of tenant support. So there may be some overlap there. Do you want to say anything about the questions, Jack?
Yeah, there's one question in relation to the penalty for failing to provide a written tenancy agreement. I think the relevant provision is clause 11, which inserts further provision about financial penalties and offences. I think the amount is £5,000.
Thank you.
But that I need to look into that in more detail. But I think that sounds about right.
Oh, excellent. 5F, by the way, is a mandatory ground. It's not going to change much in terms of the early numbers are mandatory, and then it goes on to be discretionary. So it's a mandatory ground. When we might see regulations about rent-to-rent schemes, I don't know. I mean, there's no indication. And in a sense, despite the long-running nature of this whole process, which Jack outlined at the start, there is still a lot to do. And there is still a lot to do, in both sectors, social and private sector. And so whether they do it, as I said right at the start, in changes to this legislation as presently drafted, in the regulations, or indeed in separate legislation, is a matter of debate, with the kind of big question mark as to, are they going to be able to do it before the election? And obviously I'm not able to predict the outcome of the election, but I'm not having any money on Michael Gove being the Secretary of State afterwards. Let's just put it that way. But, you know, a lot of these changes are not unpopular changes. The abolition of Section 21, you know, for example, is a popular, well, popular amongst some people. It's a popular change, I would have thought, amongst the main parties. And some of the changes are not that controversial, such as 2 months notice requirements for a rent increase in the private sector. That seems eminently reasonable. Although there may be some greater debate about some of the possession grounds and the amendments to them and the new grounds, I don't think, you know, those are a matter of tinkering, I think. But it is going to be a real question of whether they're going to be able to do it in time.
Yeah, and so in terms of exact timescales, I think the short answer is there are no exact timescales. A lot of it is down to the parliamentary diary and down to political will. And so it's, I mean, Parliament can get together very quickly and get legislation passed when it wants to. But here, it's not clear how quickly and when they're planning on getting it done.
And one of the questions was about a fixed term AST and about key workers. And there are key worker provisions. For example, if somebody stops being a key worker, that's a ground for possession. Or if the property is needed for a key worker, that becomes a ground for possession. The point about fixed terms is that in broad terms at the moment, I mean, this could change, of course, but at the moment, the idea is if you have a fixed term AST, that will continue as a fixed term until its end. And at the end, it will convert to an assured periodic tenancy. So that's the plans of the transitional provisions. Just checking if there's anything. Somebody talked about getting a new IT system. Yeah, I think you'd be very bold to do that. You know, because to be honest with you, this took so long to come out, and you'll recall, those of you who are really following it, it was, I think, about 2 weeks after it was promised, because there was suddenly what was quite clearly a lot of backbench concern about the impact on private landlords, and that continues. It's fair to say, and the issue about over-regulation of a particular sector, in this case, the private rented sector. But as I say, although the focus has been on private landlords, and although certain things like the rent increases are primarily to do with private landlords, there is, of course, a massive impact on the social sector, both in terms of shared ownership and in terms of the ending of fixed terms and the requirement that you must offer assured tenancies. And that obviously will have an impact on some associations and other private registered providers. Is there any other questions, even if you mistype it with bad spelling mistakes? I'm just checking that I haven't. Apologies if I have missed anything, but it may be because I don't know the answer and I'm pretending I haven't read it. With rent arrears, it's anticipated that this will need to be referred via the PRS and the mediation process. I'm not entirely sure what's meant by that, but I mean, of course, remember, you've got the pre-action protocol. In fact, I did a webinar this morning on this, on rent arrears pre-action protocol. And of course, you're meant to be going through that if you're a social landlord. If you're a private landlord, you're still subject to the practice direction of pre-action protocol, but But yes, it's an interesting one as to whether the mediation process, and let's be honest, in the housing sector, I don't think things like housing courts have gone away. And I certainly don't think things like, for example, I'm not suggesting these are good ideas, but there are still ideas that have been around. Issues like moving disrepair to the tribunal system has gone away. Again, I'm not suggesting that's good or bad as an idea, but I do think this is part of a process. Of course, government normally suffers from a lack of joined up thinking, but that's certainly part of a process. Will leaseholders be affected by the rent increase provisions? Well, shed owners maybe, but leaseholders shouldn't be affected by it. No, this is purely, remember, related to assured tenancies. So they're not directly affected by these. How will market rented properties be treated? Well, obviously, this is where it's mainly aimed at. It's mainly aimed at the market rent. It's mainly aimed at saying that, this is how you deal with it. And it's fair to say that Jack and I were talking at lunchtime about, if you were really saying about the private sector, what's wrong with it, I think most people would say is that, well, there's a problem about being able to stay in a property. In other words, people are having to move, and that also involves issues of the deposit and so on that we talked about earlier, but also about rent. And rent is incredibly high, particularly in certain parts of the country. And there's nothing in this act that's going to change that, because there's still, yes, you have to give 2 months provision, and yes, of course, you can be subject to the Section 13, and you have to go through the Section 13 process. But to be honest with you, I don't think that's going to change the fact that rents for many people are unaffordable.
And it's also worth noting on that, in London, Sadiq Khan recently was asking for powers to be able to set caps on rents, and it seems based on press reports that the Labour front bench isn't very keen to support that policy. So there's a little bit of a gap between the mayoral politics and the Labour front bench politics in terms of what the view is on that. But it doesn't look like there's going to be any drastic changes in terms of affordability of rent anytime soon.
Very interesting question about how will the removal of Section 21 affect the provisions on retaliatory eviction, which do not apply to Section 8. I mean, I rather suspect, I haven't thought about this, Anne, to be quite frank, but I rather suspect it would go, wouldn't it? Because, if a landlord has arrears and is able to prove arrears, it's difficult to know why they wouldn't be entitled to possession of the property. The difference, of course, with a Section 21 is that the tenant may have done nothing wrong at all. In fact, quite the opposite. And yet, because they're fighting for their rights, they were, treated badly by the landlord who said, right, I want you out. Well, of course, that doesn't apply if you have done something wrong. And by that, of course, I don't mean, they may not be able to afford it, of course, but if that is a ground of possession, the landlord's entitled to rely on it. So I rather suspect retaliatory eviction has gone. But as I say, people can obviously to make clear to courts and so on that they have to prove their case. Changes to the Protection from Eviction Act 1977. There's not a great deal, is that, Jack? I don't think, in terms of
that's to do with unlawful eviction and harassment. Effectively,
yeah.
The main provision is in relation to the introduction of civil penalties.
Yes, I don't know, Annie, if there's anything in particular you were looking at in terms of the Protection from Eviction Act. But by all means, type in something if there was. John talks about currently registered providers use AST as a type of probation check. Absolutely right. Starter tenancies, or whatever you want to call them, are ASTs. How will they operate under the regime? Well, they don't, do they really? But it does mean that, for example, if you're not happy with somebody, you could still call it a probationary tenancy if you want. But of course, whereas in the past you could have used a Section 21, you're going to have to say, we're not happy with you because you've got rent arrears. We're not happy with you because you've got you've committed ASB, or a member of your household has. We're not happy with you because you've damaged the property, or whatever the issue is. And then you're going to have to show to court, either as a mandatory ground or a discretionary ground, sufficient evidence to show that you're entitled to possession. So yes, that's why I said earlier that it's not just about private landlords, and it's going to change private registered providers as well, who are going to have to think about products like that. Although, of course, remember that the regulator of social housing would always prefer, and always has preferred, the landlord to come up with the best tenancy. And that's not always been the case, whereas now, of course, there'll only be one tenancy you can provide. I don't think there's many Rent Act tenancies left, although there are a few, of course, but they're going out. So yeah, so it's going to be it's going to be assured tenancies and secure tenancies for local authorities, and introductory tenancies for local authorities. Anything else at this stage? I mean, what I would say is this is it's at an early stage. Jack and I wrote that article, primarily Jack wrote that article because we wanted to set the marker down to the fact that there was a lot of interesting things in the Act. There's a lot of important information in the Act, but that it was to some extent bereft of detail in certain areas. And what we're going to be doing is we're going to be updating the information from Chambers. And for example, I'm meant to be writing something on social landlords and the bill. And there'll be other people in Chambers writing on different aspects of the Act. So keep an eye out for that. We're not normally shy about pushing that on social media. So keep an eye on that. And I rather suspect we'll also be doing other webinars on particular aspects of the Act, such as maybe rent increases or particular aspects, such as grounds of possession or something like that. And indeed, we're quite happy to listen to any ideas that people have as to what you would find particularly useful. But if there are no further questions, what are we now? We're 4:08, well past my home time. Unless there are any questions, can I thank you so much for attending in such good numbers? Very much appreciated as always by us here at Chambers. Hope you've enjoyed it. And as I say, this is just the first of a number on this particular topic. And we look forward to seeing you either in person or remotely at some stage in the near future. So thank you very much. And whoever's got the button will now be pressed.